G'day, friend. Let's watch some court hearings. Everyone is innocent until proven guilty in a court of law. The commentary and editing provided in our videos are in line with the principles of fair use, as outlined in Section 107 of the United States Copyright Law. So sit back, relax, and enjoy this video. Don't forget to smash the like button, pounce on the subscribe to get our latest content, and comment with the timestamp of your favorite moment.
Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth? You gotta speak in the mic.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Sir, your attorney has advised me you wish to change your plea from not guilty to no contest. Is that what you want to do today?
Yes.
Okay, are you sure? And you're thinking clearly today? I need you to answer out loud.
Yes.
Okay. I was handed a plea form with your name at the top. Is this your signature at the bottom?
Yes.
Did you have enough time to read over it and understand that you'd be giving up some constitutional rights today, such as your right to go to trial?
No.
Okay. Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No.
No? Okay. And I have to tell you, if you're not a U.S. citizen, you could be deported based upon this plea. Are you aware of that? If you were not a U.S. citizen?
Yes.
Okay. All right.
Sorry, Your Honor, if we could plead to the bench in this case?
Based on what I was told, I'm not willing to undercut the state's offer.
Okay,
This
understood.
All right. Sorry. So, sir, I do find that you're alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll adjudicate you guilty and sentence you to 15 days in the Orange County Jail. You do have credit for 2 days' time served. Okay? All right. You have 30 days to appeal the judgment and sentence in this case. It must be in writing, and you have the right to an attorney. If you can't afford one will be appointed for you for purposes of appeal. Okay? All right. Thank you, sir. This court cost prosecution, I'll reduce it to a civil judgment. All right, good afternoon. Tell me your name, please.
Raekwon Enslow.
All right, Mr. Enslow, you're here today for first appearance. You were arrested for conspiracy to commit armed robbery with a firearm, conspiracy to commit aggravated assault, and unlawful use of a two-way communication device. Probable cause has been previously found by the warrant. I will appoint the public defender to represent you. The state wish to be heard?
Yes, Your Honor. As charged right now, count 1 and count 2 are both second-degree felonies. Defendant is entitled to a bond. However, had it not been a conspiracy, it would have been an F1 and defendant would be held no bond. Based on the allegations, Your Honor, that defendant and a co-defendant were both covered with a mask, went to the victim's home, held him at gunpoint, rifled through his vehicle, and this is all based on them becoming aware that he gained some money, I believe it was from his mother. I don't remember if it was from her death or if it was just a settlement, but he had come into some money, and there was probably a third defendant that is out there. State would be asking for defendant to be held no bond, Your Honor. And that would be pursuant to 907.0415C. And as I stated, as of right now, he is entitled to a bond, but the state is requesting that he be held no bond.
Pursuant to Arthur or the pretrial detention statute?
Pursuant to the statute, but it would be 5C instead of 5D.
So, Your Honor, if I could be heard?
Yes.
Your Honor, as the state has mentioned, this would be pursuant to the permissive provision. As it currently stands, it is an F2. My client is entitled to a bond, Your Honor. I understand that the facts that the state put on record, Your Honor, but as it currently stands, these are just allegations. I do believe, Your Honor, that a large bond would be appropriate. I do want to remind the court that he is entitled to the bond. I understand that you have that discretion, Your Honor, but unless it is a F1, unless it is punishable by, not even an F1, unless it's punishable by life, or it is a, oh, I apologize, sorry. I thought I apologize. Yeah, unless they can be held via Arthur or through the PTD mandatory hold, Your Honor. I just think at this point, these are just allegations. I understand the severity of them, but he is entitled to that bond. I would like to remind the court of that, and I think a large bond would be appropriate.
See, I'm having trouble pulling up the statute at this particular moment. Can you just elaborate on the 5C provision?
The 5C is for any enumerated offense, Your Honor, but if it is not punishable by life, capital, or a first-degree felony, then the state has to put on exigent circumstances, Your Honor, which is why I gave you the allegations within the affidavit. That is, so I start off by stating, as of right now, he is entitled to a bond, and that's why I have to put on the exigent circumstances, because then it becomes the court's discretion as to whether or not to do that. And if the court agrees, then we go from there. Pretrial detention hearing is still set, and the state still has to file the motion.
Your Honor,
Well, I mean, he was out on bond and another serious offense, so the bond is going to be revoked in the out on bond case.
which I understand, Your Honor, and that isn't necessarily a debate for me at the very least. I understand why you would revoke that bond, Your Honor, but I just want to stress to the court that these are allegations, that he is entitled to the bond as it currently stands, and we would ask that you give him one.
So if I find exigent circumstances, it has to be set for a pretrial detention hearing, or it's, okay. So in this case, I am going to find exigent circumstances based on the violent and dangerous nature and the facts as alleged by the state. So I am going to hold him on no bond as to counts 1 and count 2.
I apologize, Your Honor. I apologize. It would only be with regard to count 1. With regard to count 2, he is entitled to a bond, and that does not rise to the level. That would only be an F3. So I couldn't ask for detention on count 2 or 3, and I do apologize.
Okay, so on count 1, he'll be held on no bond. On count 2, bond will be set at $5,000. And then on count 3, bond will be set at $5,000. And then I'm revoking bond on his out on bond, which is the 2024 CF 78960 case. So can we get a date for the pretrial detention?
Pretrial detention be heard in Division 18th on December the 1st at 9 a.m., courtroom 7B.
Okay. Sir, you're not to have contact with any co-defendants or victims or witnesses while you're in jail or out of jail, okay? I am appointing the public defender to represent you. If you do get out at a later date, you're just staying in contact with them. Do not possess any weapons or firearms, and do not return to the scene of where this allegedly occurred.
Also, the warrant says surrender.
The warrant also says that you need to surrender any weapons or firearms within 24 hours to law enforcement. All right, good afternoon. Tell me your name, please. All right, Ms. Hyatt, you're here today for initial appearance. You're here because you were arrested for attempted tampering with physical evidence and possession of drug paraphernalia. Probable cause was found by warrant. Your bond is set at $1,500 on count 1 and $250 on count 2. I'm going to appoint the public defender to represent you. So if you do bond out, please stay in contact with them. On count 1, I'm going to reduce your bond to $500.
Instead of 1,000, Your Honor?
Well, she's
Or
got
12.
500 and 250, so it's 750 total.
Thank you.
Antoine Johnson? Okay. Oh, okay. Good afternoon, sir. Tell me your name, please.
Antoine Johnson.
Oh, Your Honor, briefly for Mr. Johnson, I had it's not necessarily a PC challenge per se. It's I believe it should be one or the other. It is when you have a moment, Your Honor.
I'm good.
Okay. He was charged with resisting with violence, and he was charged with on law enforcement officer. Appears duplicative to me, Your Honor.
Does the state have any objection if I RR him on one of the resisting cases, or?
Your Honor, I would prefer that you set one as a subsidiary, but I get defense's argument. They have different elements, so it is permissible to set them to charge both.
We would ask for you to ROR, Your Honor.
So sir, you're here today for first appearance, if I didn't say that already. I'm going to appoint the public defender to represent you. So you have 3 charges. One's resisting an officer with violence, one is resisting an officer without violence, and the third is battery on a law enforcement officer. My reading of the probable cause affidavit, I do believe there's sufficient probable cause. However, I do believe that the charges are somewhat, they're not egregious in my opinion. So on count 1, I'm going to reduce your bond to $1,000. On count 2, I'm going to reduce your bond to $500. And on count 3, I'll set your bond at $1,000. So it's $2,500 total.
Thank you, ma'am.
All right, if you do bond out, you need to stay in contact with the public defender's office. Do not possess any weapons or firearms, and do not use alcohol to the point of intoxication, okay? Can I have the state and defense approach on the next one? All right, good afternoon. Tell me your name, please.
Dr. Mack.
All right, you're here today for first appearance. I'm going to appoint the public defender to represent you. You're going to be held on no bond. Is he going to have a pretrial detention hearing or no?
Yes, Your Honor.
Oh, okay. You will have a pretrial detention hearing, and that will be December 1st?
Yes.
At 9 a.m., okay? I have appointed the public defender to represent you, so they will be out to discuss the case with you. Probable cause was previously found in the warrant.
No, I didn't know if you were going to give conditions or if you wanted
Oh.
to.
The conditions will be no contact with the victim, no contact with any minors.
Something wrong with the mic?
It's just, it's too far away from them.
Something wrong with the mic over there because the court reporter cannot hear the defendant.
Can't hear me at all, or can't hear?
Defendant.
I can barely hear them.
Is it on? Is it plugged up?
I think it's just too far away from them. Yeah. Okay, sir, can you come to the microphone and tell me your name, please?
Good afternoon, Marcus Robinson.
Is she here now?
Can you hear me?
We're just having some audio issues. Oh, this is the attorneys online? Okay, counsel, can you hear me? I can't hear him.
Good afternoon, Your Honor. Can you hear me now?
Yes, now I can hear you. Is this your client?
I represent Marcus.
Robinson, correct?
Yes, Your Honor. 25 CF 015103, a warrant for burglary.
Okay. All right, Mr. Robinson, you're here today for first appearance. Your attorney is online. You were arrested for the charge of burglary of a dwelling and criminal mischief. Probable cause was previously found in a warrant. Counsel, did he say his name on the record? Did you say your name on the record?
Benjamin Abdul Noor.
Okay. Would you like to be heard as to bond?
Yes, Your Honor. Mr. Robinson has no prior criminal conduct, and also the warrant that was issued for him is a glorified civil dispute. The address in question is 930 Rivcon Avenue. Yes, Your Honor. I can hear you perfectly. Can you hear me?
It's delayed.
Yeah, I'm just listening. I didn't say anything. What? Can you hear me? What's the state's position on bond?
Your Honor, a defendant is entitled to a bond. A burglary of a dwelling is a second-degree felony.
Counsel, did you hear that?
There seems to be a delay and a repeat, Your Honor.
Okay, we'll call you right back. Can you hear it now?
You're, yes, Your Honor. I can hear you perfectly.
Okay. What is your, I understand you said that this is a glorified civil dispute. Probable cause has been found for burglary. The standard bond schedule is $7,500, correct? Okay, what is your position as to monetary bond?
We would ask for 2,500. What's happening? We would ask for 2,500 on the burglary. Lives there. Hello?
Your Honor, am I able to make a statement?
Wait, what'd you say, sir?
Am I able to make a statement?
No, as a friend of the court, don't make a statement. They'll hold you to that.
Okay, at this point in time,
Your Honor, I have read the affidavit. Based on the allegations, state would have no objection to the $2,500 bond for the burglary of a dwelling. However, as I believe defense was trying to say, the defendant lives there, so it would be a no return and no contact, Your Honor.
all right. Counsel,
Your Honor.
Counsel, I've spoken with the state. I don't know if you heard that, but she has no objection to the bond being set at $2,500. However, he will not be able to return to the scene until you see the trial judge and get that modified. So he can't return to the home. I can't do anything else about it at this point in time. This is just initial appearance. But I'm sure you can get a court date soon enough to get that issue resolved. So on count one, I'll set the bond at $2,500. And on count two, the bond will be stayed at $150. So for right now, you're to have no contact with the alleged victim, no return to the scene. You could do a one-time return with law enforcement to obtain some personal belongings. Is that okay with the state?
Yes, Your Honor.
Okay. And then, of course, this can be modified by the trial judge at a later date.
Your Honor, state would
Thank you,
also,
Your Honor.
Hold on one second.
state would also ask for no weapons or firearms.
Okay, so you're also not to possess any weapons or firearms while you're out on bond, okay? If you have any, you need to surrender them to law enforcement within 48 hours. Okay. Thank you, counsel. Good afternoon. Tell me your name.
It's Williamson.
You get,
Eugene. It's Williamson, Eugene.
oh, okay. Are you Mr. Williamson? Yes, okay. All right, you're here today for arraignment. You're charged with trespass. Is this one that can be resolved?
Your Honor, there was an offer conveyed to Mr. Williamson, but we are not confident that he would understand the offer conveyed to him. So we would just ask for a plea of not guilty, or to enter a plea of not guilty and to schedule him for a pretrial conference.
Okay, we're going to schedule this for a pretrial conference. The defense has entered a plea of not guilty for you. What's that court date?
Case to be heard in Division 84. Pretrial conference is January 22nd at 8:45, courtroom 4B.
All right, thank you.
Is the public defender appointed?
I'll appoint the public defender if they haven't been appointed yet. Good afternoon. Tell me your name, please.
Justin Ellis.
Justin Edwards? Okay, thank you. You're here today for arraignment. You're charged with driving while license suspended with 2 priors.
Justin. Thank you.
I'll appoint the public defender to represent you if they haven't been appointed yet.
Your Honor, there was an offer conveyed to Mr. John Edwards. I wasn't able to speak to him in the back. This will be very, very brief, Your Honor. I just have to. I just wanted to confirm. Yep, Your Honor. Go ahead.
Could you have, maybe Ms. Portlander can speak to him because this one is enhanceable?
He won't be going through with it because of that.
Oh, okay. All right. Okay, so we'll enter a plea of not guilty for you in the pretrial conference date?
Case to be heard in Division 82. Pretrial conference is January 22nd at 8:30, courtroom 4F.
Okay, thank you, sir. All right, good afternoon. Tell me your name, please.
Oscar Perez Castro.
Okay, Mr. Perez Castro, you're here today for arraignment. You're charged with operating a motor vehicle without a valid license. I'll appoint the public defender to represent you, and we'll enter a plea of not guilty on your behalf.
Case to be heard in Division 63. Pretrial conference is December the 18th at 9 a.m., courtroom 6C.
No, that's why we weren't able to convey
Okay.
the offer to him. Yes.
Okay. So we're done?
Yes, Your Honor.
Okay.
Yeah, I wouldn't be able to properly advise him.
Okay. All right, so you'll have court on the 18th, okay? All right. Good afternoon. Tell me your name, please.
I'm Kalita Williams.
All right, Ms. Williams, you're here today for arraignment. You're charged with operating a motor vehicle without a valid driver's license.
I plead guilty.
There was an offer conveyed on Ms. Williams' 2 cases. She had 2 state misdemeanors in 1 case and no valid driver's license on the other, Your Honor. It was a withhold credit time served on both.
Madam Clerk, I sent an email about 2 days ago saying that there were 2 cases where I made offers that were not on the docket. Then yesterday, oh no, actually it probably was Friday.
I was on vacation, so I didn't get.
It was sent to you.
Okay, can we get the case number? Maybe she can pull it up.
Certainly. It's 25 MO 402 911. 402 911.
All right, Ms. Williams, so it's my understanding that you want to plead no contest to those 2 cases. Is that correct?
Yeah, I plead guilty. Not guilty. No contacts. No
Okay.
contents.
All right, but you understand you're pleading guilty or no contest to 2 cases? Is that your understanding? So one of them is the operating a vehicle without or driving without a valid license, and the other one is, I guess, a resisting or state misdemeanors?
Yes.
Are you thinking clearly today?
Yes.
Okay, have you taken any drugs or medication that's affecting your thinking?
No.
Okay. You understand that you'd be waiving your constitutional right to go to trial in these cases?
Yes.
Okay. And have you had enough time to talk to your attorneys about these cases?
Yes.
All right. Has anyone forced, threatened, or coerced you into entering into the plea to these cases?
No, ma'am.
Okay. All right. I'll accept your pleas of no contest to the 2 charges. I'll find that you're alert and intelligent and represented by counsel. I'll withhold adjudication and sentence you to credit for time served. You do have 30 days to appeal the judgment and sentence in this case. I'm sorry, there's court cost of prosecution in both cases, okay?
Okay.
I'll give you 18 months to pay everything, okay? After 18 months, you could set up a payment plan if you still need more time, okay?
Okay.
All right, so you have 30 days to appeal. The appeal must be in writing, and you have the right to an attorney if you can't afford one when I'll be appointed for you for the appeal, okay? So you'll be released as to these 2 cases. Good luck to you, ma'am.
Thank you so much.
You're welcome.
Madam Clerk, can I get the credit time served on the no valid, please?
20 days.
Thank you.
Good afternoon. Tell me your name, sir.
Jean Antoine.
Okay, Mr. Jean Antoine.
There was an offer conveyed to him, Your Honor.
Okay.
It was adjudication after 45 days, Orange County Jail. I believe he has credit for 33 days.
All right.
It's a sign off.
Mr. Antoine, will you raise your right hand to be sworn in, please?
Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, sir, your attorney has advised me you wanted to plead no contest to this case. Is that what you want to do today?
Yes, I would like to plead no contest.
Okay, and you're thinking clearly today?
Yes, ma'am.
All right, I've been handed a plea form with your name at the top. Is this your signature at the bottom?
Yes, it is.
All right. Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No, ma'am.
Okay, and so if you understand that by entering into this plea agreement, there'll be no trial and you would not have the opportunity to contest this charge. Is that your understanding?
So, yes, I understand that.
Okay. All right, I'll find that you're alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll sentence you to 45 days in the Orange County Jail with 34 days time served. I'll adjudicate you guilty and require that you pay court costs of prosecution, and a public defender's lien. Is this a no return?
Yes, Your Honor. No return to the Hang Ten Car Wash located at 3700 South Orange Blossom Trail.
Okay, sir, so you can't return to that address for at least a year, okay?
Yes, ma'am.
All right, I'm going to convert all your fines and costs to a civil judgment. You do have 30 days to appeal the judgment and sentence in this case. If you want to appeal, it must be in writing, and you have the right to an attorney. If you can't afford one, one will be appointed for you for the appeal, okay? All right, good luck to you, sir.
So you're saying you...
All right, good afternoon. Tell me your name, please.
Carlton.
All right, Ms. Carlton, you're here today for arraignment.
Yeah, Your Honor, there wasn't an offer conveyed. We would like to enter a plea of not guilty and schedule for retrial conference. I believe she has regional conflict counsel. We would ask that we could just be appointed provisionally, and then we would conflict it out later on down the road.
Okay, ma'am, I'll appoint the public defender to represent you. It may be the case that they'll have to conflict off, and then you'll get another court-appointed attorney, okay? But somebody will be out to see you. If you do bond out for some reason, make sure you do reach out to the public defender's office or regional conflict counsel. the public defender's office should be able to help you get to the right person, okay? Just to make sure you don't miss any future court dates. Enter a plea of not guilty for her.
Case be heard, Division 63, pretrial conference is December the 18th,
Ma'am? Okay, December 18th is your next court date, okay?
9 a.m. Well, at 1:30.
If they send me to Seminole County and I'm in Seminole County, how would that work?
Your attorney will probably know, so they can waive your appearance and try to work out something for you, okay?
Madam Clerk, I apologize. You were saying the time?
At 1:30.
Thank you.
Okay, good afternoon. Tell me your name, please.
Philip Andrew Locke.
Okay, Mr. Locke, you're here today for arraignment.
Your Honor, there was an offer conveyed to Mr. Locke. It was a withhold, credit time served, no return. He has been advised, he just needs a signature.
All right, Mr. Locke, if you could raise your right hand to be sworn in, please.
So I swear to affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, your attorney advised me that you wish to change your plea from not guilty to no contest to this petty theft charge. Is that what you want to do today?
Yes, Your Honor.
Okay, and I was handed a plea form with your name at the top. Is this your signature near the bottom? Did you just sign the plea form?
I did. Just
Okay, so the plea form has some constitutional rights that you'd be waiving by entering into this agreement, such as your right to go to trial. Is it your understanding that you'd be waiving that right today to go to trial in this case?
yes, it is, Your Honor.
Okay, and are you thinking clearly today?
Yes, I am.
Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No one has, no.
Okay. I'll find that you are alert and intelligent and represented by counsel. I will accept your plea of no contest as charged. I will withhold adjudication and sentence you to credit for time served. You have how many days?
18.
You have 18 days time served, okay? You'll have some court costs, a cost of prosecution. You're not to return to 1600 East Buena Vista Drive for at least a year. Are you going to have any income when you get out?
I'm on disability and have limited income of $900 and some a month.
Okay, I'll reduce your court costs and fines to a civil judgment. You do have 30 days to appeal the judgment and sentence. The appeal must be in writing. If you can't, you have the right to an attorney. If you can't afford one will be appointed for you for the appeal. Okay?
Thank you.
All right, good luck to you, sir. All right, good afternoon. Tell me your name, please.
Campbell?
All right, Donovan Campbell? Okay, you're here today for first appearance. You're charged with loitering or prowling and resisting an officer without violence. I do find probable cause based on the charging affidavit, and I'll appoint the public defender to represent you. Your bond will be stayed at $250 on count 1 and $500 on count 2. All right?
$250 on count 1, and how much on count 2? $500?
Yes.
You want any conditions?
Sir, if you do bond out, you're not to return to the scene where this allegedly occurred, where the loitering and prowling occurred. Okay? Anything else the state is seeking?
No, that's fine. Thank you, Your Honor.
Okay. All right, thank you. All right, good afternoon. Tell me your name, please.
Corey Corbin.
All right, Mr. Corbin, you're here today for initial appearance. You were arrested for open container violation. I do find probable cause based upon the charging affidavit, and I'll appoint the public defender to represent you.
Your Honor, there is a plea. We were going to enter a plea today.
Okay.
So the agreement with the city was an adjudication of guilt and credit time served.
All right, sir, is that what you want to do today?
Yes, ma'am.
Okay, can you raise your right hand and be sworn in?
You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Say it again.
Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, sir. So I was handed a plea form with your name at the top. Is this your signature at the bottom? Okay, well, you know you have the right to go to trial in this case if you want to, but you'd be waiving that right today by entering into this plea agreement. Is that your understanding that you want to waive that right? Okay, you're shaking your head yes. All right, has anyone forced, threatened, or coerced you into entering into this plea agreement?
No.
All right, and are you thinking clearly today?
Yes.
Okay. I'll find that you're alert and intelligent and represented by counsel. Accept your plea of no contest as charged. I'll adjudicate you guilty and sentence you to credit for time served. How many days? 2?
2.
You have 2 days time served, okay? So you'll be released as to this charge. You do have 30 days to appeal the judgment and sentence in this case. If you want to appeal, the appeal must be in writing, and you have the right to an attorney. If you can't afford one will be appointed for you for the appeal, okay?
Okay.
All right. I'll reduce, you're going to have some court costs and fines. I'll reduce those to a civil judgment, okay?
All right.
All right. All right, he'll be released as to this charge. Good luck to you, sir.
All right, I thought we could reduce them. I thought we give them, but,
All right.
to civil judgment, I have to just type out an order, so it kind of slows me down. But I'm listening though.
Okay. Good afternoon. Tell me your name, please.
Amy Duncan.
All right, Ms. Duncan, you're here today for initial appearance. You were arrested for trespass in a structure. I do find probable cause based upon the charging affidavit.
Your Honor, Ms. Duncan would like to plead to the bench today for this case.
Your Honor, state did not make an offer, and the victim in this case was the defendant, was the 70-year-old man who shot. This is the trespasser, Your Honor. So that is why the state did not make an offer, because it actually is a residence, and there are more things involved than just it being a simple trespass.
It's abandoned.
Okay, so would the state have any objection? Does she qualify for pretrial release? No.
No, Your Honor, she's out on ROR right now. She's got an open case, so she wouldn't qualify.
Does the state have an objection to me reducing her bond?
To,
ROR?
because she is already out on ROR, Your Honor, yes, the state would object.
The defense would also like to point out that the charges are not similar. So she's out on ROR for the possession of cocaine and possession of drug paraphernalia, but this is a trespass case. She also did serve 2 months in jail for the felony case. So the incident was August 26th. She was ROR'd on October 22nd. So it was about 2 months that she was in jail for that case.
I'm not going to revoke her bond on, well, can she afford any amount of bond?
She can afford $100, Your Honor.
Okay, I'm going to set the bond at $100. You're not to return to the location where this allegedly occurred. I've ordered that the victim in this case, which is also a defendant in his own case, you're not to have contact. I'm not aware of the situation. You don't need to tell me, but I just don't want you all to have contact, so that's clear. So make sure you stay 500 feet away from the location where this occurred, okay? All right. I am appointing the public defender, so please make sure you stay in contact with them if you're released. Any other conditions?
No, that's fine, Your Honor. And just to confirm, no action on the out on bond?
Correct. I'm not going to take action on the out on bond. All right, good afternoon. Tell me your name, please.
Jason Gamble.
Okay, sir, you're here today for initial appearance. I have reviewed the charging affidavit, and I do find probable cause for the charge of battery. Yes. All right, okay. So let's start over. Okay, so you did tell me your name. This is Mr. Gamble. You are here today for first appearance. I have reviewed the charging affidavit, and I do find probable cause. I'm going to be determining conditions of your bond and contact with the alleged victim. So I would like to hear from the witness. So ma'am, could you tell us your name?
Shauna Flowers.
Okay, can you raise your right hand to be sworn?
Do you solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, does state wish to inquire?
Yes, Your Honor. Good afternoon, ma'am.
Good afternoon.
How do you know the defendant?
He's my brother.
While this case is pending, do you want him to have any contact with your family?
I don't want him to have contact with my goddaughter, the victim.
Okay. So he can have contact with you, just not your goddaughter?
More so no hostile contact for me.
Okay.
Because he likes to be aggressive. So no hostile contact for me.
Okay.
But for the sake of my mom, elderly like person that needs me, I would need to be able to communicate with her, and he resides there at her house.
Where your mother lives right now, are there any minor children?
No. Not living there, no.
Okay. Can you briefly say why it is that you came in today?
I called law enforcement last night when I was made aware that he touched my goddaughter on her vagina. He also cut her onesie.
Okay.
So for what reason did he touch her? What reason did he grab her vagina? This is not the first time this happened.
Okay.
And she is special needs, so she has an intellectual disability, and I'm her guardian.
Okay.
So that's why I'm here.
Thank you very much, ma'am.
Okay. Does defense wish to inquire?
The defense does not wish to inquire, but we would like to speak to the court.
I can barely hear you.
Sorry, Your Honor. The defense does not wish to inquire, but we do wish to speak to the court.
Okay.
Mr. Gamble does not have any prior criminal history according to the face sheet, and if the state suggested that they may upfile this charge, and then in that event, Mr. Gamble would be rearrested. So at this point, we would ask for a bond that's not extremely high, since he's going to end up potentially facing an even higher bond in the future.
Okay. Based upon the facts as alleged, I'm going to set a bond of $25,000, or I'm going to increase the bond to $25,000 rather. The allegations are very troubling, and I believe that there might have been an error made in the initial the way it was categorized. He also has an out-of-county warrant out of Osceola County, and he does have a bond in that case of $1,000. In regards to conditions for this case, the Orange County case, he's to have absolutely no contact whatsoever with the alleged victim. No in-person contact, no third-party contact. He's to have no contact with any minor children. So does the state feel comfortable with him being able to reside with his mother? Because I think that's where this occurred.
Your Honor, one of the things that I asked the witness is whether or not there are any minors at the home. I believe the testimony is that there are no minors there. So with the condition of no contact with the victim and no contact with minors, I believe he can return to the home, Your Honor.
Okay, so he can return to the home, which is with his mother. Okay.
I'm sorry, ma'am?
I just want to make sure that he's not able to access any weapons as well.
Of course. So he's not able to access any weapons or no weapons or firearms. If you possess any weapons or firearms, they need to be surrendered to law enforcement within 24 hours. I'm also going to order no use of any alcohol or illegal drugs. I'm also going to order no hostile contact with the alleged victim's immediate family members. Any other conditions?
Nothing from the state, Your Honor.
Okay. I did appoint the public defender to represent you, so you'll need to stay in contact with them should you be released. All right, thank you, ma'am.
Mr. Gilbert?
All right, good afternoon. Tell me your name, please.
James Gilbert.
All right, can you raise your right hand to be sworn in?
You solemnly swear from the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Your Honor, Mr. Gilbert will be entering a plea today. The agreement with the state is an adjudication of guilt and credit time served. We also ask if you would consider taking no action on his out on bond status due to this plea in the case.
All right, sir. Your attorney has advised me that you want to change your plea from not guilty to no contest. Is that what you want to do today?
Yes, ma'am.
Okay. And I've been handed a plea form with your name at the top. Is this your signature at the bottom?
Yes, ma'am.
All right. Have you had enough time to go over this plea form with your attorneys?
Yes, ma'am.
Okay, so you understand by signing the plea form, you'd be waiving your right to go to trial in this case? And
Yes.
to contest the charges? Okay. And you're thinking clearly today?
Yes, ma'am.
Has anyone forced, threatened,
No.
or coerced you into entering into this plea? Okay.
No, ma'am.
All right. I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll adjudicate you guilty and sentence you to credit for time served. How much time served?
It's 2 days.
You have 2 days' time served, okay?
Yes, ma'am.
You're going to have some court costs and costs of prosecution. I'll give you, in a public defender's lien, I'll give you a year to pay that. You need longer?
Maybe right now I'm unemployed, so.
Okay, I'll give you 18 months to pay everything, okay? It's going to be around $300.
Okay, yeah.
You do have the right to appeal the judgment and sentence in this case. The appeal must be in writing. And you have the right to an attorney if you can't afford one will be appointed for you for the appeal, okay? In regards to his out on bond, does the state wish to be heard?
In exchange for the plea, Your Honor, the state has no objection to no action being taken.
All right, sir, you're out on bond on some other drug cases. You know, I would hope that you could try to find some treatment.
Yes, ma'am. I'm waiting right now, currently to go to the treatment house in Sarasota. I'm just waiting on the bed to open up.
Okay.
Yes, ma'am. So thank you.
All right, well, I'm not going to take action on your out on bond case, but I really hope you can get some treatment, okay?
Thank you so much.
All right, thank you. You're good to go. All right, good afternoon. Tell me your name, please.
Jordan?
All right, Ms. Jordan, can you raise your right hand to be sworn in?
Do you solemnly swear from the testimony you should give the truth, the whole truth, and nothing but the truth?
Today, Ms. Jordan will be entering a plea of no contest to the charge of possession of drug paraphernalia. The agreement with the state is an adjudication of guilt and credit time served.
All right, ma'am, is that your understanding, that you're going to plead no contest?
Yes, ma'am.
Okay, so by doing that, you'd be giving up your right to go to trial in this case. Is that what you want to do?
Ma'am.
And I was handed a plea form with your name at the top. Is this your signature at the bottom?
Ma'am.
Okay, and you're thinking clearly today? You're not under the influence of any drugs or medication? All right, have you had enough time to go over this case with your attorneys? All right, has anyone forced, threatened, or coerced you into entering into this plea agreement?
Ma'am.
All right, I'll find that you're alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll sentence you to credit for time served.
2 days.
She's got 2 days' time served, and I'll adjudicate you guilty. You'll have some court costs, cost prosecution, and a public defender's lien. I'll give you 18 months to pay those costs, okay? You do have 30 days to appeal the judgment and sentence in this case. The appeal must be in writing, and you have the right to an attorney. If you can't afford one, one will be appointed for you for purposes of the appeal. Does state wish to be heard on the out on bond case?
In exchange for the plea, Your Honor, state has no objection to no action being taken.
Okay, ma'am, I could have revoked your bond on this other drug case that you're out on bond for, but since the state is not asking for that, I'm not going to do it at this time. But I really would suggest that you try to get some drug treatment, okay? All right, good luck to you. So no action on the out on bond. All right, good afternoon. Tell me your name, please.
Calvin Lane.
All right, Mr. Lane, can you raise your right hand to be sworn in?
Do you solemnly swear from the testimony shall give the truth, the whole truth, and nothing but the truth?
I do.
Mr. Lane will be entering a plea of no contest today to the charge of resisting an officer without violence. The agreement with the state is an adjudication of guilt and credit time served.
Okay, sir, is that your understanding? Okay, so you want to plead no contest to this charge? I was handed a plea form with your name at the top. Is this your signature at the bottom? So by signing this, you're acknowledging that you're waiving certain constitutional rights, such as your right to go to trial in this case. Is that your understanding? Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No, ma'am.
All right. And you're thinking clearly today?
Yes, ma'am.
All right. I'll find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll sentence you to credit for time served. You get 2 days?
2 days.
2 days, and I'll adjudicate you guilty. You have some court costs, cost prosecution, and a public defender's lien. I'll give you 18 months to pay that, okay? All right, you have 30 days to appeal the judgment and sentence in this case. The appeal must be in writing, and you have the right to an attorney. If you can't afford one, one will be appointed for you for the appeal, okay? All right, good luck to you, sir. All right, good afternoon. Tell me your name, please.
Lily Mays.
Okay. All right, Ms. Mays?
Yes, ma'am.
You're here today for initial appearance. You're arrested for petty theft. I do find probable cause. I'll appoint the public defender to represent you. Does she qualify for pretrial release?
No, Your Honor, she's on probation in Osceola.
Okay. I'm going to reduce your bond to $50.
Your Honor, she's out on bond for a petty theft. I mean, she is on probation for a petty theft. She was just placed on probation in September.
Can you afford to bond out?
If you reduce it to $50, yeah, I can.
Yeah, I'm going to set your bond at, I'm going to reduce it to $100. I understand the state's argument and over their objection. You're going to have to find a better way, okay?
Yes, ma'am.
No return, Your Honor?
No return to the scene for at least, and then I'm appointing the public defender to represent you. Make sure you stay in contact with them, okay?
We'd ask to waive that appearance.
Okay, on Gianna Penley, I'll find probable cause, appoint the public defender to represent them, and bond will be stayed at $500.
No return, Your Honor?
No return to the scene. All right, good afternoon. Tell me your name, please.
Evan Jamal Taylor.
Taylor?
Yes, ma'am.
Okay, you're here today for initial appearance. You're arrested for possession of cannabis less than 20 grams. You're also out on bond for possession of fentanyl and possession of drug paraphernalia. I do find probable cause. Your bond will be stayed at $500. Sir, I'm not going to take action on your other out on bond case, but I could revoke your bond and you'd be here without any bond. Okay? Please stay in contact with your public defender.
And the next defendant qualifies for PTR.
All right, good afternoon. Tell me your name, please.
Elena Balobina. Good afternoon.
Balobina?
Yes.
Okay. You're here today for initial appearance. You were arrested for possession of an open container and failure to provide ID identification to law enforcement. I do find probable cause, and I'll appoint the public defender to represent you. Your bond will be stayed at $500 on count 1, and I'll reduce your bond to $100 on count 2.
Your Honor, may I have 1 moment to speak with her, please?
Okay.
Your Honor, if she qualifies for pretrial release, she would like to do that.
Okay, ma'am, you'll be released on pretrial release. Make sure you stay in contact with your pretrial release officer and your public defender, okay?
Any special conditions, Your Honor?
Don't get arrested
I have to ask. I just have to ask. It's fine if not.
Okay. All right, good afternoon. Tell me your name, please.
Kayam Farajo.
Okay. All right, you're here today for your initial appearance. You were arrested for what's called state misdemeanors, which was essentially resisting an officer without violence.
Your Honor, he will be entering a plea today in this case.
Okay.
He'll be entering a plea of no contest, and the agreement is a withhold of adjudication and credit time served.
All right, can you raise your right hand and be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay. So you can put your hand down. Your attorney has told me that you wanted to enter a plea of no contest to this charge. Is that what you want to do today? Okay. We have to move on. Are you sure?
Yes, my lawyer recommended me yes.
Well, it has to be your decision. I mean, she can give you advice, but I have to make sure it's your decision.
I'm sorry. It's my first time ever. I got handcuffed at all, and I have no too many imagination about the legal termination. But that's why I'm referring to my lawyer and I'm agreeing.
Your Honor, the defendant has no history and the offer was a withhold. State would have no objection to an ROR as long as he can stay in contact with the public defender's office.
Okay. Sir, I have no problem releasing you on your own recognizance as long as you'll stay in contact with your public defender and then come to your next court date. Okay? All right. So I'm going to release you on your own recognizance. However, make sure you, is he going to get a court date? For arraignment? Okay, so you're going to have an arraignment. It's going to be December 18th at 1 o'clock. No, okay. So I'm going to release you today on your own recognizance. That means you have to come back, and I'm appointing the public defender. They could possibly waive your appearance.
Oh, no, I was just going to ask what language the defendant is more comfortable with.
Which is fine.
Okay.
Okay. So you're going to have an arraignment date on December 18th, but I just need you to stay in contact with the public defenders. You could talk to them on whether or not you need to be there or not.
Sure.
Okay? So that's it.
Your Honor, do you want us to take the plea form back from you?
I just ripped it up.
Oh, okay, perfect.
Okay. All right. Good afternoon. Tell me your name, please.
Bobby Lee Harris.
All right, Mr. Harris. Can you raise your right hand to be sworn in, please?
Solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth.
Yes.
Okay, counsel?
Mr. Harris will be entering a plea of no contest today. The agreement is an adjudication of guilt and credit time served.
Okay, sir, is that your understanding?
Yes, Your Honor.
Okay, I was handed a plea form with your name at the top. Is this your signature at the bottom?
Yes, ma'am.
So you understand by signing this plea agreement, you'd be waiving certain rights, such as your right to go to trial and contest this charge?
Yes, ma'am.
All right. Has anyone forced, threatened, or coerced you into entering into this plea agreement?
No, Your Honor.
All right. And you're thinking clearly today?
Yes, ma'am.
All right. I'll find that you're alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I will sentence you to credit
One day.
credit time served. You have 1 day time served, and I'll adjudicate you guilty. You'll have some court costs, cost prosecution, and a public defender's lien. I'll give you 18 months to pay those costs. Oh, sorry, just court costs. Okay, it's $223.
Yes, ma'am.
I'll give you 18 months to pay that, okay?
Yes, Your Honor.
You do have 30 days to appeal the judgment and sentence in this case. If you want to appeal, it must be in writing, and you have the right to an attorney. If you can't afford one will be appointed for you, okay? All right, good luck to you, sir.
Thanksgiving.
Thanks, you too. Okay, good afternoon. Tell me your name, please.
Denise Sturgis.
Can you say your name?
Sturgis, Denise Sturgis.
Yes.
And today, Ms. Sturgis will be entering a plea of no contest. The agreement is going to be an adjudication of guilt and 5 days in OCJ.
All right, Ms. Sturgis, can you raise your right hand and be sworn in, please?
Solemnly swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, Ms. Sturgis, your attorney has advised me you wish to change your plea from not guilty to no contest to this charge. Is that what you want to do today?
Yes, I do.
Okay. And I have a plea form with your name at the top. Is this your signature at the bottom?
Yes, it is.
Okay, so by signing this, you're acknowledging that you read and understood the constitutional rights you'd be giving up by entering into this plea, such as your right to go to trial?
Yes.
Is that your understanding?
Yes.
Okay. Are you thinking clearly today?
Yes.
All right. Has anyone forced, threatened, or coerced you into signing this plea agreement?
No, sir.
Okay, I find that you are alert and intelligent and represented by counsel. I'll accept your plea of no contest as charged. I'll sentence you to 5 days in the Orange County Jail with credit for 2 days, okay? All right, you'll have some court costs, some costs of prosecution. I'll give you 18 months to pay that. You do have 30 days to appeal the judgment and sentence in this case. The appeal must be in writing, and you have the right to an attorney. If you can't afford one will be appointed for you for the appeal. Okay, good luck to you, ma'am.
Okay, thank you.
All right, good afternoon. Tell me your name, please.
Tiago Oliveira.
De Oliveira? Okay. All right, you're here today for operating a vehicle or driving without a valid license. You're here for your first appearance. I do find probable cause based upon the charging affidavit, and I'll appoint the public defender to represent you. Your bond is set at $500. Can you afford that?
Yes, again.
Okay. All right. Your bond will be stayed at $500. If you bond out, make sure to stay in contact with the public defender and don't drive unless you have a valid driver's license, okay?
Yes, ma'am.
All right.
He does have an immigration hold, Your Honor.
Okay. Well, it looks like you have an immigration hold. All right. Okay, we got to move on. All right, good afternoon. What's your name? What's the last name?
Ramdas.
Okay.
Who bonded? Okay, thank you.
Okay, so you are Mr. Ramdas? Okay. Sir, you're here for your first appearance. You were arrested for driving while license suspended or revoked and operating a vehicle without a valid driver's license. I do find probable cause for those offenses, and I'll appoint the public defender to represent you. Your bond is set at $500 on count one, and I'll reduce your, because it's only one.
Mind, Your Honor.
Okay, I'll release you on your own recognizance on count two, because it's essentially the same thing.
What is count two, Judge? Is it the no valid or what is count two?
It's, yeah, driving without a valid license.
So you are on that one?
Yeah. Okay, and make sure, I'm appointing the public defender, so make sure you stay in contact with them, okay?
And he does have an immigration hold.
You also have an immigration hold. Okay, good afternoon. Tell me your name, please.
Rivera?
Okay, Mr. Rivera, you're here today on, you had a failure to appear on a driving case.
Your Honor, Mr. Rivera has advised me that he did receive notice in the mail after the court date, and his license has been reinstated. So if we could just reinstate the bond to give him time to present that to the court and resolve this case.
Your Honor, I understand the dilemma, but unfortunately, unless it's in your courtroom, we cannot reinstate the bond. And unless clerk can pull up something that would indicate that he now does have a valid license, it's going to stay at no bond. Yeah.
Your Honor, I apologize.
It seems as though this would be his third conviction, so the offer was an adjudication in 10 days. So I understand the court's dilemma, but unless the clerk can provide some paperwork.
I have a driving history. I don't know if it'll help.
Does it indicate that?
Indicates suspended.
Okay.
And
that's recent?
I printed it off today, Your Honor.
Okay. I understand if it was in my courtroom, I would give him a bond, but I can't do it in this particular case. There was a KPS and that judge said no bond.
He's indicated that he he can pay any amount of bond and he can get his driver's license immediately as soon as he's released. He just needs to have an opportunity to get out of jail.
I'm willing to reset it for tomorrow if you want to try to reach out to the state attorney assigned to the case.
And I don't know if this will change anything, but just so you're aware, he does have an Osceola County no bond hold, so even if he did, he would be going over to Osceola, so he wouldn't be released.
Okay, so then I'm not going to reset it.
We would ask then if he has an Osceola County no bond hold, if there could be some kind of bond set in this case, so then he can just get transferred to Osceola and deal with the case there.
I can't do that in this case. If it's a different judge, she issued a no bond capias. I'm not going to touch that right now. Perhaps you could reach a global resolution on the two cases somehow, okay?
And was the PD appointed to this case?
I will appoint the public defender if they haven't been already.
Yes, they were. Was previously set.
All right, good afternoon. Tell me your name, please.
Yeah, Brown.
All right, Ms. Brown, you're here today for first appearance. You were arrested for driving while license suspended as a habitual offender. I do find probable cause for the offense. I'll appoint the public defender to represent you. Your bond is going to be stayed at $5,000. The state wish to be heard on the out on bond.
Your Honor, as you state the bond at $5,000 on the new law offense, state has no objection to no action being taken, as the state was going to ask that you revoke and double on the out on bond.
Okay.
As I'm standing up, state would request that 25 CF 15387, currently in Division 17, be transferred to Division 15, where there is a lowercase number pending.
Okay, I'll grant the transfer. So, ma'am, I'm not going to revoke your bond on the other case. You can't drive unless you get a license, okay?
You've been appointed, correct, Your Honor?
If I didn't say it, I'll appoint the public defender, so make sure if you do bond out, stay in contact with them, okay?
Thank you, Your Honor.
All right, good afternoon. Tell me your name, please.
Michelle Campbell.
All right, Ms. Campbell, you're here today for your initial appearance. You were arrested for a possession of cocaine, paraphernalia, and cannabis less than 20 grams. I do find probable cause based upon the charging affidavit.
Your Honor, I'd like to emphasize my client's lack of criminal convictions in their history when you decide on bond.
I'm just having a hard time hearing you because.
Okay, I would like to emphasize that my client has a lack of criminal convictions when you make your decision on bond, Your Honor. It's a relatively, I believe she only has arrests. She's never been convicted of a crime.
You have a place to stay?
Yes, I have a house in Esto, Florida.
Okay, you don't have to tell me the location. All right, on count one, I'm going to reduce your bond to $2,500. On count two, I'll reduce your bond to $500. And on count three, I'll reduce your bond to $100. I'm going to appoint the public defender to represent you. You do need to stay in contact with them. I would encourage you to get some treatment. You don't have to respond, but and I'm going to order that you, well, I was going to order her not to return to the scene, but I'm not going to do that. Okay. All right. Thank you, ma'am.
I'm sorry, Your Honor, did you order it or not?
No, I thought it was like a specific business, but then I looked at it again and.
And the next defendant qualifies for PTR.
Okay. All right. Tell me your name, please. Your name?
Noemi Chaldrub.
All right, you're here today for your first appearance. You're charged with a battery on a law enforcement officer. I do find probable cause based upon the charging affidavit, and I'll appoint the public defender to represent you. You do qualify for pretrial release. Do you know if she would like to do that?
I believe she would like to. I believe she would like to, Your Honor.
Okay, I will order that you're released on pretrial release with the following conditions. You're not to use alcohol to the point of intoxication, okay? And any other conditions you're seeking? Okay. Just stay in contact with the public defender's office, okay? All right, good afternoon. Tell me your name, please.
Carlos Cruz Garcia.
All right, sir, you're here today for first appearance.
Your
You
Honor,
were-
we'd ask to waive the reading of the, I believe you know what charge I'm referencing, Your Honor. I don't know if it's the fifth one or the first one for you. Can you not hear me?
It's just, there's a lot of background noise, so it's a
I
little bit.
apologize, Your Honor. We'd ask to waive the reading of the, I believe it may be, it's the fifth charge or either the first or the fifth. I don't know how it's going to show up for you.
Your Honor, it would be the only charge that actually does have a bond.
Right?
That's what he wants you to.
Yeah, but I mean, you're not saying that he's entitled to bond on the other four?
Yes,
Okay,
I'm
I just want to make sure I'm understanding. I understand, but why don't we just waive reading as to all five? I mean,
I just,
I do find probable cause for all five of the charges. The state wish to be heard as to the bond amount.
No, Your Honor, I'll leave it at the court's discretion.
Okay, so I have found probable cause as to all five charges. On count one, I'm going to set the bond at $15,000. On count two, I'm going to set the bond at $5,000. On count three, I'm setting the bond at $25,000. On count four, I'll set the bond at $2,500. And on count five, bond will be stayed at $1,000. You're not to have any contact whatsoever with the alleged victim in this case.
Your Honor, I just want to confirm that you've looked at my defendant's lack of criminal history before you made your decision. That's all, Your Honor.
Yeah, okay. Your Honor, were you done with the conditions? State has a request.
No.
Okay.
I'm not sure how the lack of criminal history would affect my decision in this particular case.
For the bonds, I just wanted the court to consider it, but I understand that you have discretion with the bonds, Your Honor. I just wanted to bring it to your attention.
Can I have the attorney's approach?
Yes.
So let's go over the conditions again if you do bond out. So you're to have no contact with the alleged victim. You're also not to have any, not to use any rideshare services such as Uber, Lyft, or taxis. Okay? You're also not to possess any weapons or firearms and not to use alcohol or any illegal drugs. Did you say there's an immigration hold?
There's not at this time.
Okay. Did I cover everything? Okay. All right, I did appoint the public defender, so if you do bond out, make sure you stay in contact with them, okay? All right, thank you.
Oh, sir, I apologize. I should have given this to you.
All right, good afternoon, sir. Tell me your name, please. Dexter? Mr. Dexter? Okay. You're here today for a first appearance. You're arrested on a possession of cocaine case. Your probable cause was found through the warrant. Your bond is set at $1,000 in that case. Sir, you're also out on bond for possession of cocaine. The same charge. Does state wish to be heard?
State would ask that you revoke and double, Your Honor. And candid to the court, defendant was arrested back in August, and formal charges have not been filed yet.
Okay.
And that's what I'd like to emphasize, Your Honor. It does stem back to, and I appreciate the state with the candor. We would just ask for no action at this point.
Sir, I'm not going to take action on your out on bond case, but you really need to get help, okay? You don't need to say anything, but I really hope you can get some treatment, all right?
State is requesting that 25 CF 12802, currently in Division 16, be transferred to Division 22, where there is a lower case number pending.
Okay, that's granted.
May I approach?
Yes. All right, good afternoon. Tell me your name. Oh, tell me your name, please.
My name is Lincoln Felix, Your Honor.
Okay, Mr. Felix, you're here today for first appearance. You were arrested on possession of a firearm by a convicted felon. I do find probable cause exists in the charging affidavit. I'll appoint the public defender to represent you. Is this a F3 or F2? Can't remember.
F2, Your Honor.
Okay. Your bond's going to be set at $7,500. If you do bond out, you're not to possess any weapons or firearms, okay?
Yes, Your Honor.
Stay in contact with the public defender.
Yes, ma'am.
And the next defendant qualifies for PTR.
Okay. All right, good afternoon, sir. Tell me your name, please.
Timothy Gallen.
All right, Mr. Gallen, you're here today for first appearance. You're charged with fleeing or attempting to elude a police officer, possession of cannabis less than 20 grams, and resisting an officer without violence. I do find probable cause for those charges. I'll appoint the public defender to represent you. You do qualify for pretrial release. Would you like that or a monetary bond?
Pretrial release.
Okay. I'll release you on pretrial release. You need to make sure you stay in contact with your pretrial release officer as well as your public defender, okay?
Okay.
All right.
Any conditions, Your Honor?
Sir?
No conditions. All right, good afternoon. Tell me your name, sir.
James Giovinazzo.
All right, you're here today for first appearance. You were arrested for possession of cocaine and possession of drug paraphernalia. I do find probable cause for those two charges exists in the charging affidavit.
Your Honor, before you make a decision on bond, I'd like to emphasize the last issue that my client has had. It was a conviction from January 21st, a day before my birthday, actually. It was a disorderly conduct. We'd ask you to take that into consideration. I believe he's also employed and he's firmly grounded within the community. So please factor those in when you make a decision on bond, Your Honor.
Sir, do you have a way to get in contact with your attorney if you bond out? What? You're gonna get contact information for the public defender. Do you have a phone and a way to contact them? No? Do you know where the public defender's office is?
Well, Your Honor,
Do you have an
we,
arraignment date?
do you, give me, if I could just, I'll be very brief with my question, I'll be very brief.
Your Honor, state has no objection to reducing the bond, but cannot agree to an ROR based on the testimony that he has no way to keep in contact with the public defender's office.
Doesn't look like, Your Honor, it doesn't look like he would be able to bond out. Going forward, we would make an attempt to modify that bond, but as of right now, I think we'll be able to make, we'll be in contact with the defendant because he'll be in custody, so we would just ask for a low bond in the event. I think at that point, we'll have enough rapport with him and know where he is and be able to figure out a way to get a hold of him when, if he is ever let out.
Okay, sir, I'll reduce your bond to $500 on the possession of cocaine case and $100 on the drug paraphernalia case. That can also be modified at a later date. I have appointed the public defender, so if you do bond out, make sure to stay in contact with them, okay? All right, good afternoon. Tell me your name, please.
Samaj J. Harris.
All right, Mr. Harris, you're here today for a first appearance. Excuse me. You were arrested on 5 charges. The first is burglary of an occupied structure. Count 2 was grand theft, 20,000 or more. Count 3 was criminal mischief, 1,000 or more. Count 4 was dealing in stolen property, and count 5 was providing false verification of ownership to a secondhand dealer. Probable cause was previously found in the warrant. State on count 1, the warrant shows it as burglary of a structure while wearing a mask, so I believe that would be an enhancement.
Yes, it usually is, Your Honor. I'm reading it now to make sure that is actually what happened.
Okay. I will appoint the public defender on this case for you.
Yes, Your Honor. There were co-defendants, and both of them had masks on.
Okay, so what level does it bring it to?
I believe it's an F1. From that, Your Honor. An F2, Your Honor.
So he is entitled to bond?
Yes, Your Honor.
One today.
And just so the court knows, count 1, 2, and 4 are F2s, Your Honor.
Schedule 7,500 or
Yes.
10? Okay.
It's 7,500.
All right, on count 1, I'll set your bond at 7,500. On count 2, I'll set your bond at 7,500. On count 3, your bond will be stayed at 2,500. On count 4, your bond will be increased to 7,500. And on count 5, your bond will be stayed at 150. You also have an out-of-state warrant out of Monroe County, Georgia. So the extradition department will come see you on that case, okay? I did appoint the public defender. If you Special conditions of your release is you're not to have, not to return to the scene, you're not to have contact with any co-defendants or victims. You're not to possess any weapons or firearms. You need to stay in contact with the public defender's office.
Say not-
Yeah, no return.
You have Monroe County. You have to extradite you. Sir, I promise. Read that, you'll get an attorney. Ask that attorney what you're asking me, okay?
All right, good afternoon. Tell me your name, please.
Harold Hayes.
Mr. Hayes, is that you?
Yes, ma'am.
Okay, sir, you're here today for your initial appearance. You were arrested on a possession of cocaine case and possession of drug paraphernalia. I do find probable cause exists in the charging affidavit. I'll appoint the public defender to represent you. Your bond's going to be stated $2,500 on count 1 and $500 on count 2. Sir, if you're unable to bond out, I would encourage you to take advantage of some of the programs here at the jail. Okay? If you do bond out, please stay in contact with the public defender's office, okay?
What was the total bond? I apologize.
$2,500, I just stated it, so $2,500 on count 1, $500 on count 2.
And the next defendant qualifies for PTR.
Okay.
Your Honor, briefly, with Mr. Haywood, this is a very, very brief probable cause argument on the battery on the law enforcement officer. It just it just doesn't read to me. I want to be precise. That at any point the law enforcement officer mentions when he had been battered. It's really.
Well, I'm focusing on the second paragraph from the bottom of the first page. You want to take a look at that?
I know that statement that they had a tussle, but I would it doesn't, from how that supposedly occurred, Your Honor, that reads to me as resisting. But I understand you have discretion here to, your probable cause is very low, but that reads as resisting to me, Your Honor. He at no point, usually when there are batteries on a law enforcement officer, an officer will say, he grabbed my wrist, he punched me, he did something along those lines. The tussle.
Well, he grabbed the duty belt and yanked it upward. I mean, that's what I.
Oh, I may have, okay. I may have missed that, Your Honor. No, you don't want to go in.
This is not the trial, it's just probable cause, but I mean, is there,
I may have.
is there a financial issue in regards to bond?
No, Your Honor, I may have missed that. I'll take a look, but I just didn't see an overt action that would have suggested a battery on the law enforcement officer. But if that's in that fact pattern, Your Honor, then probable cause would be met.
Your Honor, I believe that this defendant does qualify for PTR.
Okay. Okay, this is just the probable cause stage. So I do find there's sufficient probable cause in the arrest affidavit. Sir, you do qualify for pretrial release. Would you like to be released on pretrial release, or would you like a monetary bond?
I'm sorry, I'm not really used to like the legal proceedings.
Okay, well, pretrial release is a program where you would be released in lieu of a financial bond. So you wouldn't have to pay money, but you have to report to a pretrial release officer, just I think monthly, typically, just to make sure you're still in the area and you know when your court date is and that sort of thing.
I'm visiting for Friendsgiving. I literally was supposed to fly out yesterday afternoon.
Would he be able to do phone in?
Yeah, the out-of-staters do call in.
Okay, so you could, basically, do you want to talk to him about it?
About the monitoring, Your Honor?
Yeah, just see which one he wants to do.
Honor, we would ask for a bond, and we would ask you to consider the fact that he has very minimal record, Your Honor. He has no in-state record. I don't necessarily see.
Well, okay, I don't really understand why he wouldn't want to do pretrial release. He just has to phone in, but,
If it's just the phoning,
If it's just the phone, that's fine. I manage a caregiving business up and down the East Coast. I just can't be isolated. The business is located in Pennsylvania. I have to be responsive to the seniors that I'm.
I mean, it's up to you, but,
Yeah, no, I'll take the. She said pretrial.
okay. All right, so you'll be released on pretrial release. You actually don't qualify for the public defender based upon your income. Okay, so you'll need to hire your own attorney, okay? Do we have a future court date for him? Okay, so this is how it's gonna work. We don't have a future court date for you right now. The state might make a filing decision, so you're gonna have to check in with the clerk of court. You can find that online if you look up your case using your name or case number. That's how you'll find your next court date, okay? They should mail it to you, but if I were you, I would double check with the online system, okay, the clerk of the court. But if you hire an attorney, of course, they would take care of that for you, okay?
Yes, ma'am.
Your Honor, you just have to order that defendant can travel.
Okay, so I'll order that you can travel, but I'm gonna order that you research your court date, just so you don't miss your court date, because then you'll get a warrant out, and that'll be a huge mess, okay?
Any other conditions other than just can return to Georgia?
Just make sure you're not taking any drugs unless you have a prescription. So no illegal drugs, and all legal drugs you must have a prescription for, okay?
Even the charges for my prescription drugs. Yes, ma'am.
Yes, sir.
All right. Good afternoon. Tell me your name, please.
Samantha Himmel.
All right, Ms. Himmel, you're here today for first appearance. You were arrested for possession of cocaine, possession of cannabis, and possession of drug paraphernalia. I do find that probable cause exists in the charging affidavit. She's also out on bond for a petty theft charge. Has the state filed on that?
No, Your Honor, defendant was arrested September 18th. Formal charges have not been filed yet.
Okay, I'll take no action on the out on bond case since charges haven't been filed. Can she afford the bond as it's set?
Your Honor, she was hoping for pretrial release. She can't. I'm assuming pretrial services would have let us know if she was eligible. Would Your Honor consider a reduction in the bond amounts?
All right, ma'am. I'll reduce your bond on count 1 to $1,000. On count 2, I'll reduce it to $100. And on count 3, I'll reduce it to $100. Please consider that a gift and get yourself some help, okay? All right, stay in contact with the public defender's office. Good afternoon. Tell me your name, please.
Andrew Leonard Lewis Jr.
All right, sir, you're here today for your first appearance. You had a capias on a larceny, or maybe it's a petty theft case.
Yeah.
What?
Price.
Okay, petty theft with 2 priors, looks like. Okay, the bond is set at $1,500. That's what was put in the capias, okay? I'll appoint the public defender to represent you.
There was no return to the scene. Weapons and no.
No return to the scene, don't possess any weapons or firearms, and
No contact.
no contact with the victim. All right, sir, come to the microphone, please. Tell me your name.
Ezekiel Lindsay.
Mr. Lindsay?
Yes, ma'am.
Okay, sir, you're here today for your initial appearance. You're arrested for fleeing, attempting to elude, and possession of cocaine. I do find probable cause exists in the charging affidavit. I'm going to set your bond at $2,000 on count 1. And I'll reduce your bond to $1,000 on count 2. Sir, you cannot drive without a valid license, okay? All right. I'm appointing the public defender to represent you. Please stay in contact with them. All right. Good afternoon. Tell me your name, please.
Madrano Romero.
All right, sir, you're here today for first appearance. Say wish to be heard.
Yes, Your Honor, as probable cause has been found.
I didn't say that yet. So actually, I'm sorry. No, you're correct. Sir, probable cause was found in the warrant.
As probable cause has been found, state is requesting that defendant be held no bond on counts 1 and 2, as they are both first-degree felonies that are enumerated offenses. And that is pursuant to 907.0415D.
Okay. All right, sir, on count 1, it is a first-degree felony, so you're going to be held on, probable cause has been previously found for all counts through the warrant. So you will be held on no bond as to count 1 and count 2. On count 3,
It's an F2.
okay, your bond will be set at $7,500, and on count 3, your bond will be set at $7,500, and on count 5, that's a misdemeanor?
Yes, Your Honor.
Okay. On count 5, your bond will be set at $1,000. You're not to have any contact with the alleged victim in this case, or any co-defendants, or any witnesses. If you do bond out, you're not to possess any weapons or firearms, and you need to stay in contact with the public defender's office. I'm appointing them to represent you on all counts. or all charges. You need to surrender any weapons or firearms to law enforcement within 24 hours. You're also out on bond in 2025 CF 12687AO. I'm going to revoke bond in that case. Does he get a hearing?
Yes, he does, Your Honor.
Okay, so he does get a pretrial detention. It's going to be December 1st at 9 a.m. All right, good afternoon. Tell me your name, please.
Latoya Moreland.
All right, Ms. Moreland, you're here today for a first appearance. You have 2 charges, petty theft, 2 or more priors, and petty theft of $100 or more. A probable cause has been found in the warrant. And your bond is currently set at $1,500 on count 1 and $250 on count 2. I'm going to appoint the public defender to represent you. If you do bond out, make sure you stay in contact with them. Do not return to the scene. No contact with the victims.
Yes, ma'am.
Okay, thank you, ma'am. All right, good afternoon. Tell me your name, please.
Michelle Nipper.
All right, Ms. Nipper, you're here today for first appearance. You're here on 5 counts. Probable cause has been, I find probable cause based upon the charging affidavit. Oh.
Your Honor, with regard to count 5, probable cause should not be found as is charged. My reading of the affidavit, the trafficking substance is Adderall. If they were asking for a trafficking amount, it would have to be over 14 grams. As is right now, it's only 4 grams. With further research, it seems as though the appropriate charge would be possession of possession of a drug without prescription. I can give the court that if the court agrees, and that is an M2. You want the statute?
Oh, for the alleged Adderall?
Yes.
Because it's not it's not.
No, it is a controlled substance, Your Honor. But
I understand the amount, but you're still saying it would be an M2?
Yes, because the only charge that it could be would be possession of a drug without prescription. It's not a trafficking amount.
No, I understand that, but even if it's a controlled substance, it's not, that doesn't make it enhanced.
What do you mean enhanced?
Well, because typically a controlled substance, like if it was alprazolam or something else, it would be a felony, no?
Oh, yes.
An F3?
Yes, you are correct on that, Your Honor.
But that's why I was saying that maybe Adderall is different. I don't know.
I wonder why she didn't do that.
I understand it's not a trafficking amount, but
Yes, it should have been just a possession of a controlled substance.
which would be an F3.
Yes, Your Honor.
Okay. Okay, but on the sale and delivery, that would be a F2, correct?
Yes, Your Honor.
Okay, so on count 1, I'll set bond at $7,500. On count 2, bond will be stated $2,500. Does the state have any objection to me treating the others as subsidiaries?
No objection.
Okay, so on count 3, I'll reduce bond to $500, and on count 4, I'll reduce bond to $500, and on count 5, I'll set bond at $500.
And did you, it's a lesser?
Yeah, so on count 5, I'm finding probable cause for a lesser included offense of possession of a controlled substance, not the trafficking. Okay, so I'm appointing the public defender to represent you. Did you want to hire your own attorney? Okay, all right, so make sure you stay in contact with your attorney. If you do bond out, do not contact any victims or co-defendants. Don't possess any weapons or firearms. All right, thank you. All right, good afternoon. Tell me your name, please. All right, sir, you're here today for first appearance. You're here today on 5 counts. Is there an argument as to probable cause on count 1? Does that still qualify as a burglary?
This is the one where he went into the glove compartment?
Yeah.
Yes, Your Honor.
Okay. So I do find probable cause as to count 1, 2, 3, 4, and 5. I'll appoint the public defender to represent you on those charges. On count 1, your bond will be set at $7,500. On count 2, your bond will be stayed at $2,500. On count 3, your bond will be set at $2,500. On count 4, your bond will be set at $1,000. And on count 5, sorry, can the state point out the probable cause for count 5? The tampering?
That, Your Honor, would be when the gun was found by the rear left tire. That was him trying to hide the weapon, Your Honor.
Okay. So on count 5, I do find probable cause, and I'll set bond at $1,000. So that's a total of 7,000. That's 10,000, 12,530, 14,000, if the math is correct. Okay, just so you know. All right, if you do bond out, you're not to have a possession of any firearms or ammunition. If you have any, you need to surrender them to law enforcement within 24 hours. You also need to stay in contact with the public defender and no contact with the alleged victim, no return to the place where this occurred.
How much was the bond for the tampering, Your Honor?
1,000.
Your Honor.
Right. All right, good afternoon. Tell me your name, please. Your name, please?
Robert Terrell Smith.
Okay, Mr. Smith, you're here today for first appearance. You were arrested for possession of cocaine and probable cause was found in the warrant. Can you afford the bond of $2,500?
No, ma'am.
How much can you afford?
$1,000 bond.
Okay, I'll set your bond at $1,000.
Your Honor.
Okay, if you bond out, you're not to possess any drugs or alcohol. You do need to stay in contact with the public defender's office, okay?
Yes, ma'am.
All right, good afternoon. Tell me your name, please.
Soto.
All right, Mr. Soto, you're here today for your first appearance. You were arrested on possession of alprazolam and trespass in a structure. I do find probable cause exists in the charging affidavit for those offenses.
It's just the,
Can you afford to bond out?
I can't.
oh, actually,
I actually, I went to the cops myself to tell them, hey,
Okay,
my backpack is
sir,
inside.
Your Honor, I would like to, I believe, my client said he's had PTR in the past. I would just like to ask pretrial services why it doesn't have, is the charge not eligible?
No, I mean, we couldn't verify any community ties, and he does have quite extensive criminal history.
Don't do that.
All right, sir, I'll reduce your bond on count 1 to $1,500 and on count 2 to $100, but you're not to return to the scene, the Wawa, okay?
So,
I'm appointing the public defenders to make sure you stay in contact with them if you're released.
What's your bond amount?
All right, good afternoon. Tell me your name, please. All right, Ms. Stinson, you're here today for a first appearance. You were arrested on a warrant for obtaining property by worthless check. Probable cause was found in the warrant, and your bond was set at $1,000. I'm going to appoint the public defender to represent you. All right, stay in contact with the public defender if you bond out, okay? All right, good afternoon. Tell me your name, please.
Andre Washington, ma'am.
All right, Mr. Washington, you are here for first appearance. You were arrested for possession of a firearm by a convicted felon.
Last December.
Okay, hold on. My face sheet says it's a gang enhancement, but the arrest warrant doesn't say that.
Your Honor, you should go by the arrest warrant. After reading the affidavit, there is no gang affiliation mentioned, so the gang enhancement should not be.
Okay, just want to check on that. All right, and then you also have carrying a firearm in a place prohibited by law, possession of ammunition by a convicted felon, and possession of a firearm with the serial number removed. The judge in the warrant set the bonds at $4,000. I'm going to state the bonds as set in the warrant, yes. So $4,000 on count 1, it'll be stayed at $1,000 on count 2, stayed at $2,500 on count 3, and stayed at $4,000 on count 4, okay? I am going to appoint the public defender to represent you, so if you do bond out, make sure you stay in contact with them and do not possess any weapons or firearms, okay?
Your Honor, my client would ask the court if the court would consider sorry, I don't know if you heard that. My client would ask the court if the court would consider a reduction of his bonds.
I'm not going to do that at this time because the judge that signed the warrant put those specific amounts, but you can seek to have a reduction by the trial judge, okay? All right, good luck to you, sir. Thoughts?
Yes, ma'am.
Okay. All right, you're here today for first appearance. You were arrested for aggravated assault with a deadly weapon without intent to kill. Probable cause was found in the warrant for that case. And then you also have a driving while license suspended. I do find probable cause in the arrest affidavit for that offense, and your bond will be stayed at $500. I'll appoint the public defender in that case. The state wish to be heard on the ag assault?
Third-degree felony, Your Honor.
The facts, are they particularly egregious, or? What was the deadly weapon?
One moment, Your Honor. It's a handgun, Your Honor.
Your Honor, my client, go ahead, say it, I don't know if you, okay. My client just, she obviously contests the facts. Ultimately, Your Honor, we would ask for, I know it's an F3, I believe
The problem I have was that she was previously told to surrender the firearm. Upon release. No, I'm sorry, that was of the current warrant. Okay, I'm sorry, I misspoke. So it appears that as a condition of the warrant, she's supposed to surrender any firearms. Is she not able to afford a bond of $5,000?
No, Your Honor, we would ask for a bond in the amount of $2,500 if the court would consider that.
The state wish to be heard?
State will leave it in the court's discretion, Your Honor.
Without knowing more about the facts, I don't feel comfortable reducing it at this point in time. So I'm going to leave the bond, I'm going to set the bond at $5,000. And then if she needs a reduction, she can take it up with the trial court.
I understand, Your Honor, and I respect the court's decision. Would the court consider maybe something in the middle between 25 or 5,000? If not, Your Honor, I understand. You've already made your decision.
Well, let me look at her criminal history. Okay, I don't see any significant criminal history on this face sheet. So I'll do 3,000. But you need to surrender any weapons or firearms to law enforcement within 12 hours of your release from custody, okay? And you need to not have any contact with the victim or any witnesses in the case, and you need to stay in contact with the public defender, okay? No return to the scene. All right, good afternoon. Tell me your name, please.
Tyler Kane Work.
All right, so you're here today for initial appearance. You were arrested for possession of a controlled substance without a prescription. Probable cause was found in the warrant. And your bond was set at $2,500. Are you able to afford that?
No.
What can you afford?
Oh, shit. Honestly, I don't know right now. Money's tight.
Would the court consider a $500 or $1,000 bond?
Your Honor, unfortunately, my face sheet is not complete, so I don't have his history.
Yeah, he has quite a history, so unfortunately, I'm not willing to reduce the bond. It was set by the judge in the warrant. You could seek a bond reduction from the trial court, but it's going to stay at $2,500. You're not to possess any illegal drugs or no firearms. Stay in contact with the public defender. All right, is that it?
That is it, Your Honor.
Say his his name and say his name and